name is Robert Cray, and I am an investment management attorney at K&L Gates, which is a large international law firm. And as an investment management attorney, I focus most of my time on creating venture funds and hedge funds and providing advice to investment advisors and broker-dealers. And also, I do some work with emerging companies. And let me see, I have a presentation here that somewhere it's in here. Is there a way we can upload this presentation? So what we're going to do here today in the next 30 minutes is talk about the regulatory landscape for cryptocurrencies and ICOs. And my objective here is to give you an overview of where we've been, where we are, and where we're going. And we have a bit of an intimate group here, so it would be helpful for me. Raise your hand if you have done an ICO already. Okay, and raise your hand if you are thinking about doing an ICO. Okay, and all right, so that is, yes, that's right. Okay, great. Well, all right. How do we get to this top here? Can you take me to the front page? Okay, good. All right, I think we're ready. So this is a rather long presentation. It's probably too long for the 30 minutes that we have. This presentation will be available for you to download after this. And also, Hall and I have done a 10-minute podcast that gives you just a general overview of what are the securities law pathways for how you might consider conducting an ICO. But just as a threshold matter, when in this space we talk about cryptocurrencies, we talk about digital tokens, and the regulatory framework for cryptocurrencies and tokens, sometimes they overlap and sometimes they don't. One of the things we know is that the CFTC, which is the US agency that regulates commodities, has asserted jurisdiction over virtual currencies in general, and specifically Bitcoin. But then there are other cryptocurrencies, such as Ether or Monero, for example. Those are probably generally considered commodities, but there are arguments out there in this marketplace that they could be securities. But when we talk about the world of digital tokens, ICO tokens specifically, those have been construed in most circumstances as securities, as we'll discuss. And as a matter of taxonomy, when I talk about tokens, what I really mean are digital assets that are created pursuant to smart contracts on an application blockchain such as Ethereum. And in this space over the last, I'd say, 2 years, what we've also been seeing is a growing consensus of regulators across the globe about particular concerns in this space. As we know that there's been a lot of concerns about money laundering, tax evasion, cybersecurity, and also just flat out fraud. And this is a specter that has fallen across this entire industry, which is actually an impediment to its growth. But as to the securities laws, under US law, whether something is a security or not is a facts and circumstances based test. And once something is construed as a security, there are wide ramifications. In the US, we actually have a variety of securities laws. We have what is called the Securities Act of 1933. We have the Securities Exchange Act of 1934. Those are kind of the two principal main statutes. And these came in the aftermath of the Depression. And they were developed to correct a lot of concerns that people had about a lack of fairness to customers who are trading in securities. And the mission of the SEC is to promote transparency in the capital markets, to facilitate capital raising, and also to protect investors. And since the Depression, since the enactment of the Securities Act, the Exchange Act, we have in the United States what I would say is probably the most sophisticated securities law apparatus in the United States. And it is also one that I think that this sector, specifically with respect to digital assets, is challenging. It's challenging, not that in any way that it's wrong, but it's challenging it to grow, it's challenging it to be novel, it's challenging it to be malleable. And one thing that I think that we have been able to identify over the last 70, 80 years is that the securities industry is a complex one, and our regulatory apparatus has evolved along with it, and it will continue to do so. So the Dow was really kind of, I'd say, probably the first introduction of the SEC to the world of digital tokens. How many people have heard about the Dow? So, okay. So the Dow was basically, it's this really exciting idea. It was like a venture fund. It was like a decentralized venture fund where people could invest money. And the idea is that this venture fund would allocate money to other different startups. And what is exciting about it is that the idea is that it would solve the liquidity problem for limited partners and venture funds, because most venture funds are closed-end vehicles. You're locked up for 7 to 10 years. And the idea of the Dow tokens, you could buy a Dow token that's represented an interest in this venture fund type thing, and then you would be able to transfer it freely. The challenge with the Dow is that it was created pursuant to a smart contract on Ethereum, and there was a bug in it. And as a result of the bug, a quote-unquote hacker managed to take $150 million of the investors in the Dow. And there are some people who say, well, this was a hack. Other people were saying, well, no, this is actually how the code was written. The hacker just actually manipulated the code. And then, you had some discussion about, well, is code law? Well, in this case, it's not law because nobody intended for this to actually happen. So you apply fundamental principles of contract law, and this was a hack, pure and simple. And when you have something like a loss of $150 million, it attracts the attention of a lot of regulators. And in this case, it attracted the attention of the SEC. And in July of last year, the SEC delivered this seminal report, investigative report on the Dow, where it concluded the Dow tokens were securities. So, and as the Dow report is basically the foundational guidance that we have in this space. So, when is a token a security? The typical test that is applied is called the Howey test. Have you all heard about the Howey test? So the Howey test is the principal test, but it's actually not the only test. And the Howey test has 4 elements. It's an investment of money in a common enterprise with a reasonable expectation of profits to be derived from the entrepreneurial or managerial efforts of others. This is the principal federal test that applies to determining whether something is a security. There are other tests that are used throughout the United States. Specifically in California, we have something called the risk capital test, which is actually much easier to find something to be a security under the risk capital test, because it basically looks at whether or not there's an investment of money that's subject to a risk of loss. So it's harder for something to be determined to be a security under the Howey test than under the risk capital test. But they're both very similar, but in this space, we're generally talking about the Howey test when we're looking into ICOs. So over this evolution of this space, in 2017 was really the year of utility tokens. That's when everyone was talking about utility tokens. And the reason why people were talking about utility tokens is, one, a lot of the applications that were being used for smart contracts actually did have idea of consumptive use, that a token is something that you could redeem for some sort of service or a product. But another reason why people wanted to do utility tokens is because if your token is actually deemed to be a utility and not a security, then it is then transferable on a secondary market basis. And one of the things that I've observed in the several years that I've been in this space is a common denominator for most token sponsors is that they want their tokens to trade freely on a secondary market basis. Why? Because hopefully on a secondary market, somebody's going to bid up the value of those tokens. And also, the token sponsor happens to hold on to a bunch of tokens himself or herself, and hopefully as those tokens are bid up in value, the token sponsor gets rich. So, but this also raises an issue. Well, if I want my token to be a utility, and I have a startup, but I want to raise money to be able to create the platform from which is going to actually create the token, and I know that there's this thing called the Howey test out there, and I know there's also this other scarier test called the risk capital test. How do I actually manage to raise money and then also issue my token and not have my token be deemed a security? So last year, there was a lot of discussion about the SAFT. You all know about the SAFT, Simple Agreement for Future Tokens. It is a clever device, and it's one that's actually fallen under a lot of criticism recently. But a device that was basically saying, I'm going to sell you a piece of paper, and it's an agreement. It is a contract. And under this contract, you give me a certain amount of money, and I'm going to use that money to build out my platform. And then once I've finished building out my platform, I'm going to give you tokens. And I'm going to give you those tokens on a discounted basis. And so the idea is that I would only issue you these tokens after my platform is fully developed. So the framework is the piece of paper that I sell you, the contract where you agree to actually buy these tokens, that is clearly a security under either a risk capital test or the Howey test. But this token, once I subsequently issue it, it shouldn't be a security because, well, you already bought the security and this token is something that has utility. But this was actually proved to be a very dangerous strategy. And what I would say is that most of the prominent issuances of SAFs have actually yet to issue their tokens, and it's largely because of the regulatory questions surrounding the SAFT. In November of 2017, there was a group of academics and legal practitioners who organized a group called the Cardozo Blockchain Project out of Cardozo University in New York City. And this report that I have on this screen is, for anyone who's considering doing a SAF, this is a must read. And this report basically identifies all of the regulatory challenges to the theories underlying the SAFT. And it was pretty much following the issuance of this report and then a cease and desist order against an organization called Munchie in December of 2017 that largely made this industry think that the SAFT is dead as a fundraising device. So Munchie. Do folks know Munchie? Are they familiar with Munchie? So Munchie was like Yelp. Their idea was we're going to create this Yelp-like service, and we're going to incentivize people to engage with it. And so the idea is we're going to raise some money by selling pre-sale instruments. They actually never issued tokens. What they issued were SAFT-like contracts for buying Munchie tokens. And the idea behind the Munchie application was it is like Yelp, and if you write a review, you could earn Munchie tokens. And when you get your Munchie tokens, you could redeem them at restaurants. And then restaurants would like to actually get these Munchie tokens because then they could use those tokens to buy advertisements on the Munchie app. Well, in December, the SEC issued a cease and desist order against Munchie. And what they said was, and it was really in a passing reference. They didn't even really look at there was a passing reference to the fact that a pre-sale instrument like a SAFT was used, but they didn't really get into it. They just said the Munchie tokens are securities, stop. And that is something that's very telling. And it also, in the conversations that I've had with the SEC, what I have been told by staff members is they don't really think too much about the distinction between a pre-sale instrument and the token, because what they're looking at is the investment purpose. And this is why I think when you hear statements from the chairman of the SEC, Jay Clayton, who said, every ICO he has seen is a security. And so the guidance that we've gotten from Munchie, the guidance that I've distilled from Munchie, is that if you are selling your tokens, and your tokens actually have the possibility of a speculative purpose. And the people who are buying your tokens might not necessarily be the people who are going to be using the tokens on your application. Then more likely than not, the SEC is going to construe them as securities. And that was the case also here in Munchie. The people who were buying the Munchie tokens were, or the pre-sale instruments, were not necessarily hoping to actually use them on the app to buy advertisements. They were hoping that there was going to be an uptick in the value of those Munchie tokens once they were actually issued. But there's also what's really interesting at the SEC. So the SEC is governed by 5 commissioners. The president appoints all 5. And as a matter of practice and history, the president appoints a chairman, and the president appoints 2 members of his party, or her party, and then 2 go to the other party. So 2 are Democratic, 2 are Republican, and then the president chooses whoever is the chairman. And so usually it's either 3 Republicans and 2 Democrats, or 3 Democrats and 2 Republicans. Right now we have 3 Republicans and 2 Democrats. And there is a division in viewpoints within the 5 commissioners. Hester Pierce, who's often dubbed in this space as Crypto Mom, she's one of the Republican appointees. And she's taken a very strong view that is different from those of her colleagues at the commission, and has said that we should be cautious about identifying every token as a security. And she gave this really great speech in May 2nd of 2008. And in this speech, she cautioned this blanket viewpoint that all tokens or cryptocurrencies need to be securities. And what I find really funny is she made this reference to Chuck E. Cheese. And I think for anyone who's thinking about doing an ICO, this is a great analogy to keep in mind. Because you think about Chuck E. Cheese. This is a place that issues tokens, right? I can go into a Chuck E. Cheese with my fiat cash, and I can go in there and I can buy a bunch of tokens. And I can use those, redeem those tokens to play games. And I can even take those tokens outside of Chuck E. Cheese and I can sell them on a secondary basis to a kid down the street. But here's the distinction between what most ICOs have been and what is Chuck E. Cheese. Because nobody is ever going to say that Chuck E. Cheese tokens are securities. No one's ever going to say that Chuck E. Cheese needs to be subject to state money transmission laws, which are issues that many people are talking about ICOs. And here's the difference why, as I see it. The kid who's going to be buying those tokens on a secondary market basis from you is never going to pay more than what you paid for those tokens. If anything, that kid's going to pay less. And that's because the way this token was designed as a matter of its structure is that it is impossible for there to be a speculative intent in buying a Chuck E. Cheese token. Because guess what? Everyone knows you can always go into a Chuck E. Cheese. There's a rate card. How many tokens are worth how much in fiat cash, and you just pay it. That's what you can pay, and you can always buy more, and there's just no way that there could ever be a speculative purpose. So if you don't want your token to be deemed a security, think about Chuck E. Cheese, because I think that is a good model, and I think it digresses very much from what many people in the ICO space have been doing, which is really hoping that they're going to get rich on the tokens that they've created literally out of the ether. Sorry, bad pun. So 2017 was the year of the utility token. Now everyone's talking about securities tokens. And under US law, there's basically 3 paths forward that I've summarized here: regulation crowdfunding, regulation A+, and 506C. Each one of these 3 paths create a lot of different challenges for ICO sponsors, especially for ICO sponsors who want to have their tokens trade on a secondary market basis. Regulation crowdfunding, the big challenge there is it limits you to raising no more than $1.07 million a year. It also doesn't preempt state securities laws. So in the United States, we have the federal government, which is the primary regulator of securities, but basically each one of the 50 states also has its own securities laws, called the Blue Sky laws. And basically, if you're going to issue securities, you want to make sure that the regulatory framework that you're using for issuing those securities preempts the application of all those 50 states. Otherwise, you're going to have all these filing obligations, and your securities issuance actually becomes very expensive because you're dealing with New York State and Washington and California. Regulation A+ is another pathway that people are talking about in the space. That's more advantageous because the idea is, well, you can raise it up to $50 million, and it actually might go up to 75. But here's the challenge there. You have to have an offering circular approved by the SEC before you can actually issue an A+ offering of securities. And you also have to have GAAP audited statements, which if you're a startup that is just forming, it often doesn't make sense to actually have GAAP audited statements. There's been a lot of noise in the ICO space about A+ offerings. Not a single A+ offering circular has been approved by the SEC, not a one. Why is that? My speculation is that there's a chicken and an egg problem. If you're going to have an A+ offering of securities, that means that your A+ offering of tokens will be able to trade freely as soon as you do your issuance. But there isn't yet an exchange that exists that is regulated with FINRA and the SEC that can host the trading of securities tokens. You actually, to be able to be an exchange that can trade in securities, you either have to be a national registered exchange like NASDAQ or the New York Stock Exchange, or you have to be something called an alternative trading system. And there are a number of organizations that are trying to get this ATS status, but not a single one yet exists. And what I'll say is that in this space, we kind of get ourselves up in arms and twist it around about utility tokens versus security tokens. What I would submit to you today is that the greatest hurdle to the advancement of this space is the fact that the exchanges are not regulated. You have a lot of exchanges out there that have the look and feel of public securities exchanges. They have bid-ask spreads. You can do limit orders. But what we've heard abundantly clearly from not just the SEC and FINRA and also state regulators such as the New York Attorney General, that all of that look and feel is window dressing, because many of these exchanges have terrible conflicts of interest, and there's also lots of evidence that they're not doing surveillance sharing amongst themselves to ensure that there isn't fraud and manipulation happening on the market. Once we actually get a regulatory pathway for an alternative trading system or a national registered exchange for tokens, this whole space is going to take off. And it's not just the space of startups raising money. It's going to be also the opportunity for registered products, such as exchange-traded funds and mutual funds, retail investor products. And so keep your eyes on that, because for me, as an investment management attorney, that's what I find most exciting about this space. So the third pathway forward, because of the difficulties of crowdfunding and A+, the third pathway that people are talking about is Rule 506C, which is the general solicitation rule under Regulation D. The great thing there is there's no limit on how much capital you can raise, but you're limited to only selling to accredited investors. But the big challenge here is that, well, if you issue a security under 506C, you're issuing a restricted security, which means, well, how do you actually trade it on a secondary market? Because again, the common denominator for most ICO sponsors is that they want their token to trade freely. So you'll hear a number of theories on how these tokens can exchange on a secondary market. 506C tokens, that is. And I would say, whenever you speak with your advisors about this, test them on it, because lots of people have kind of fly-by-night attitudes towards it. They talk about trading on this implied exemption under 4A 1.5, or the recently codified Section 4A7, or also Rule 144. And what I would say is Rule 144 and Section 4A7 are what are called safe harbors. These are safe harbors that if you receive restricted securities, how you can actually trade them. And never, never has Rule 144, which is the most common safe harbor contemplated in this space, ever been used to create a dynamic secondary market in securities. So if you look at what's happening on Bitrex or Bitfinex or Poloniex, and you see all this activity trading in cryptocurrencies, if that's your anticipation for once you issue your 506C, that your token's going to trade like anything that's already trading on those exchanges, and that you're relying on Rule 144, what I would say is that is probably whistling in the dark. Rule 144 historically is a safe harbor. It might be theoretically possible, but historically, anyone who's been relying on a Rule 144 transaction has always required legal opinions to ensure that each transaction in a restricted security actually complies with the safe harbor. And so if you're relying on Rule 144, you're basically kind of giving that up, which means that whether or not you're relying on the safe harbor is actually, that it actually works is questionable. And what I would also say about Rule 144, there's also affiliate transfer restrictions. So there's this holding period. So after, like, say, a year, Rule 144, if you can comply with all the different requirements, you would be able to transfer it to another accredited investor. However, if that other person that you're transferring it to happens to be an affiliate of the issuer, that 1-year holding period begins again. So there's just a lot of hair. And so this is why, I caution you, when you're structuring your ICO and the discussion of securities laws come up, always ask about how you're going to actually do the transfer. And when someone says Rule 144, please keep in mind this photo. So a lot of people they just kind of throw their hands up in the air and like, well, the US securities laws they're just too strict. They're too rigorous. I can't comply with them. So I am going to just go overseas, and I'm going to structure my ICO overseas in another market that has laws that perhaps are not as evolved as the US. And so, well, that is possible. You might be able to do that. What I would say is that just because a country doesn't have specific laws doesn't mean that you're permitted to do what you think you want to do. But the United States laws, securities laws, have a long arm. And so even if you structure your ICO overseas, you still have to comply with what is called Regulation S, which is like a regulation, it's like a safe harbor to ensure that your ICO is actually not deemed subject to US law. And in the world of ICOs, that basically means you have to ensure that no US person, and all of us here are US persons, anyone who's resident, regardless of your citizenship, if you are resident in the United States or one of its territories, you're a US person. So if you structure your ICO overseas, you have to make sure that for this distribution compliance period, that your token can't fall in the hands of any single US person for a period of 12 months. That's if you're what is called a category 3, which I think most tokens would be construed as. And you know, what I think is that's actually possible to do. You can structure your smart contract to ensure that there's no transfers permitted. You can actually bar the transfer of any token on the smart contract. And I think that there is a good reason to think that if you actually have a blanket transfer restriction for 12 months from issuance, then theoretically, I think that satisfies Regulation S. Just make sure I have enough time here. Am I doing okay on time? All right, I got 5 minutes. So we talked a little bit about, at the beginning, about exchanges. I think exchanges, the regulation of exchanges is the most exciting thing to keep an eye on. You know, there's a lot of questions about whether or not a given cryptocurrency, and here I'm not talking about digital tokens, I'm talking about cryptocurrencies like Ether. And several months ago, there was discussion about whether Ether is a security, and the history of Ether is very different than the history of Bitcoin. You look at the actions of Vitalik Buterin, and you look at the role of the Ethereum Foundation and how they initially sold Ether. I mean, Ether was sold pursuant to a lot of pre-sale contracts with discounts. There was clearly an investment of money. Arguably, there might have been a common enterprise, and the people who were buying them weren't necessarily expecting to use Ether on the Ethereum platform. They were thinking that there was going to be a speculative increase in value. So given the guidance that we have from the SEC, I think a reasonable person can conclude that Ether is a security. But who gets to make these decisions? Well, there's a dispute in the SEC about whether or not Ether is a security. There's a dispute, I think, between the CFTC and the SEC. When you look at comments from the former chairman of the CFTC, of Gary Gensler, who's thought that Ether is a security. And if Ether is a security, I think that satisfies a lot of the concerns about the regulatory posture of exchanges, because every exchange actually trades in Ether. And if Ether is deemed a security, then each one of those exchanges needs to stop trading in Ether or register as an alternative trading system or a national registered exchange. So this might be where we end up, but in the end, it's not just a regulatory agency that gets to make the final decision. This decision ultimately is Congress as a matter of passing laws, but it also could be a determination by a federal court. There's a lot of class action litigation right now, specifically against Ripple, that could have cascading implications for this entire space and cryptocurrencies and specifically. And if there is a single judicial ruling, which could happen also, keep in mind, from there could be a jury determination. A jury of 12 people could actually make a conclusion about whether or not a given cryptocurrency is a security. So if there is a district court determination, say in San Jose, and then there's a different district court determination on the East Coast of the United States somewhere, we could end up having conflicting judicial viewpoints across the United States through the federal courts that would take time to actually reconcile through an appellate process and perhaps ultimately to the Supreme Court. So hopefully that there might be some congressional action in the meantime. Hopefully the agencies such as the SEC might say something. But we also have, I'm just going to point out the New York Attorney General's report on exchanges. This is a fascinating report to read. When I was talking about window dressing for the exchanges, this report identifies all of that, and it identifies exchanges by name. And unless one of their federal agencies jumps in and asserts authority, or unless Congress actually grants the authority, probably what's going to happen with these exchanges is they're going to be subject to state-by-state regulation, which I think would be a huge impediment to the growth of the tokenization of assets and also the growth of and the possibility of retail investment products such as exchange-traded funds or mutual funds in this space. So I think I'm out of time. I'm going to be out floating around for the next few hours. Happy to talk with anyone who has any questions. This presentation is also going to be available online. There's a podcast between Hall and me. I don't think I have any. Do I have time for a question? Or if we need to move on this. All right. Is it on the 10 Capital website? So anyway, thank you so much for your time. It's great to be with you this morning.